Hey, what's up, you guys? This is Noelle Brockett, and welcome back to my channel. Yay! So today I'm going to be talking about the time I went to court. Not my proudest moment. Kids stay in school, but basically this was like academic court, so like basically it was totally fine. Yeah, so let's just get started. I was in this court case called Citizens to Protect Overton Park v. Volpe. I guess that's how you pronounce his name. I don't know because he's irrelevant. So basically, it started in Memphis, Tennessee, and there was a route that was approved to go through Overton Park, which was like this national park in Tennessee, in 1956. And so then CPOP, Citizens to Protect Overton Park, was created to not let that happen. And then that was the next year, 1957. And so 1969, John Volpe, the Secretary of Transportation, decided, yes, this route is sicko mode, let's go. And CPOP was like, no. And so CPOP decided to sue him because the Department of Transportation was created in 1966. 3 years before John Volpe decided to approve this. And the Department of Transportation Act of 1966 said, Henny, you can't build something through a national park unless you don't have any feasible or prudent alternatives. And so CPOP was like, yo, we're taking your butt to court because you didn't investigate every route that you could have. And so it started in the district court, and the plaintiffs were CPOP, the Sierra Club, the National Audubon Society, and 2 individual landowners in Memphis. Their names were Dupree and Snyder, but nobody cares. And the attorneys for the plaintiffs were John Vardaman and Charles Newman. And the defendant was John Volpe, originally in the district court. When it went up to the Supreme Court, they added in Charles Spate. It was a tactic. I don't know government, so I don't know why. So it failed in the district court because the district court kind of ignored most of the entire argument, just to focus on one thing that was wrong. And they also said that it wasn't their business to be shoving their nose in John Volpe's plans for the highway. And CPOP was like, that doesn't fly with me, it is your business. So CPOP took it to the Sixth Circuit Court of Appeals, and they said, hey, listen, Sixth Circuit Court of Appeals, please hear us. And the Sixth Circuit Court of Appeals, I'm going to stop saying that, was like, yo, I agree with the district court because prudent in the feasible and prudent alternatives word means preferable. And obviously the most preferable alternative is to go through Overton Park. And CPOP was like, stop saying that! And so the Solicitor General filed for the case to be taken to the Supreme Court, and the Supreme Court was like, yes! Because the Supreme Court had this whole thing where they wanted to get more involved in, like, public policy disputes, but they didn't even know if they were allowed to, so this was the case where they got to decide if they even could decide on the case. Government. So it was argued from December 7th, 1970 through January 11th, 1971. And a couple cases that went into the argument for the plaintiff's side was, first of all, Nashville I-40 Steering Committee v. Ellington, which was when basically an African-American community in Nashville said that they couldn't reroute the Overton Park route through Nashville because that would disproportionately affect African-Americans. And the Overton Park route would only affect whites because blacks weren't even allowed in Overton Park. And they got shot down. Their case went nowhere. And that really pissed some people off. That was in 1967. And that really pissed off like environmentalists, and they were like, listen, we need to be taking these court cases further. So that was kind of where the oomph was for this case. Another thing that helped out this case was Section 701 of the Administrative Procedure Act, which was basically about when the Supreme Court got to decide what was their problem and what wasn't their tea to sip. And so the defense tried to use the Administrative Procedure Act to say, hey, this isn't any of your business. I am totally in the right because it would be like betraying the discretion of my business to like give away my plans for why I decided to do this. And the Supreme Court was like, Henty, that's not true. And so the first thing they decided was John Volpe, we're allowed to decide on this case, so take that. Then the defense tried to use the feasible and prudent part of the Department of Transportation Act and the Federal Aid Highway Act to say that, you know, this was the preferable, prudent alternative. And the court was like, but the T is, sis, that it's national policy to protect national parks, so prudent in this case does not mean preferable, because it's always going to be preferable to go through national parks, because there's no one around to relocate, and it's free real estate. So they were like, prudent does not mean that, go home. And John Volpe was like, crap. And so basically the Supreme Court didn't decide what Volpe had to do. They didn't decide whether or not Volpe was in the wrong. They just said, district court, listen, you do have a responsibility to look into Volpe. So they sent it back to the district court to decide. And the district court said, yo, Volpe, just give us your plans. You can still build the highway. Everything will be Gucci. And Volpe actually fessed up and he was like, actually, there's totally another route I could take. I just wanted to take this one because it was easier on my pockets. And so he didn't end up building it. And then in 1979, Overton Park got added to the National Register of Historic Places, so no one could develop there, which was pretty sicko mode. So, conclusion. The precedent set was any issue that might pertain to public interest could be decided by the Supreme Court as long as somebody brought it up. And before, it had all been like a political thing, and it never got outside that sphere. And so this was the case that decided, hey, the Supreme Court is allowed to take on environmental cases that affect the public and aren't just between two parties. And that was pretty sick for like the rest of environmental cases that happened. And so then they also ruled that the preservation of parklands is national policy, which meant that it's kind of take precedence over like your individual little qualms. And it also clarified that very few businesses were exempt from judicial review, so they had to be more transparent and everything. So that was a lot of talking. This video's over now. If you liked this video, leave a like, hit that subscribe button, hit the bell button if you want to be notified when I make a new video. I make a new video every single Tuesday and Thursday. So hope this was fun and fresh. I've been Noelle.